5 years ago, I was one of the 20 members in the House chamber that voted against the initial appointment of Justice McDonald to the Supreme Court. And after sitting through the judiciary process and listening to the number of hours of testimony and questions, my concerns still have not been allayed, and the original reasons why I voted against him still remain. When Justice McDonald had served as chairman of the Judiciary Committee, we heard discussion about Senate Bill 1098 that came before us in 2009. I was serving for 2 years in this chamber, and it probably was one of the biggest turning points in my life as a legislator and just on a personal level. Because when that particular bill was raised, I remember it was in March when the bill came out as drafted, and everybody was shocked that the title of the bill and its substance came out as being an act modifying corporate laws relating to certain religious corporations. And what that bill effectively was seeking to do was to statutorily reorganize the Catholic Church in Connecticut to make it so that the church could not exist in this state. And on a personal level, having been a practicing Catholic all my life, it really struck me to the core that the legislature was embarking on a potential path to eliminate my ability to practice religion in the state of Connecticut. And I remember when that legislation came out, many people, we all ran to our ranking member at the time, I think it was Arthur O'Neill, and said, how did this happen? How did we all vote for a concept that would do something like this? And after our attorneys did some research and everybody shrugged their shoulders, the concept that was raised was entitled Modifying Corporate Forms. And somehow, and we all know how this building operates, the chairs and ranking members sit down in a room and they go over the concepts to be raised. Somehow, something as significant as this was never discussed in meetings prior to this draft language hitting the floor of the chamber and of that committee room. And I remember as people sort of ran around and tried to stop the process and figure out how we prevent that bill from moving forward. And while all this was going on and the church was getting all wrangled up, the chairman of those committees set down a public hearing anyway, only to increase the anxiety of those people who are practicing Catholics throughout the state of Connecticut. And I remember going to church and hearing the announcements, and the buses were beginning to be organized and protests were being organized. And the night before the public hearing, the decision was finally made to box the bill and not go forward on the hearing. Just the night before. And all these churches had events scheduled to come to the Capitol to speak their minds. And so it was bad enough that we raised a concept that was so offensive, and it was under Justice McDonald's leadership. But then when the voices wanted to come to be heard, the chairman cancels the public hearing and prevents that opportunity. And you know what? People came up anyway. 5,000 people, it was estimated, came up to speak against that legislation. And I think for many of us, me personally, it was an embarrassing moment as a legislator that process had even occurred. Moving forward to the nomination process, and I could speak to the one where he just testified, but it was similar when he went originally in 2013 for his appointment. Justice McDonald had an opportunity to own up to what had happened on that day. And quite frankly, I was fully prepared to forgive the process and to support him in his first nomination. But to this day, I don't feel an adequate explanation was given, and that the chairman of a committee still refuses to own up to what was done. And yet the explanations that I heard during the judicial proceedings was that it was a constituent that had wanted the bill raised. People bring bills to this legislature all the time and ask us to raise them. And I know all of us go through a process of to what degree we're willing to do that. Is it appropriate? Is it prudent? I question the judgment that Justice McDonald exercised that time as a senator in agreeing to raise a bill that is so egregious to me. But then even after doing that and in the questioning, in the hearing, he intimated that the underlying statutes don't really belong in Connecticut law. And he questioned why they're even there. And that concerns me, to be doubling down on that issue. Because the reality is those statutes are needed in order for religion to exist in Connecticut, specifically the Catholic Church under its construct. That's why those statutes are there. And I have felt through the whole process the animosity that was seen and the attack that was done on a particular religion in the state of Connecticut was unbecoming of a chairman of the Judiciary Committee. And when given the opportunity to take ownership of what had happened, to apologize and move on, all I heard was deflection. And it was interesting because if you Google some of the information, the individual constituent that supposedly had proposed a bill to this day had insisted that was not the language that he was looking for. And yet the pressure was sort of put onto him and he was left scurrying, apologizing to the bishops and trying to retract what had happened. But ultimately the buck should stop with leadership. And so the fact that at the time, Senator McDonald, Justice McDonald, has, in my mind, throughout this judicial process, not taken ownership and responsibility, that behavior concerns me, especially now that we're seeking to potentially elevate him to Chief Justice. And so while I sat silently and pushed my red button 5 years ago, I can't sit silently anymore. I need to put that on the record, and I will be voting no.